Good day everyone, my name is Starlin Joy Whitekelson, and in today's video I will discuss the Probation Rules and Regulation of the Probation Act number 4103, or otherwise known as Indeterminate Sentence Law. It is approved on December 5, 1933, and I will discuss the general probation under this probation. So next, in section 1, it is a policy objective. Um, as mentioned, be- as I mentioned before, it is the Probation Act number 4103, or otherwise known Indeterminate Sentence Law. Um, it is a function of the Board of Pardons and Parole to uplift and redeem valuable human material to economic usefulness. So the main point of this probation is to redeem our guilty persons or the prisoners inside the prison. It is a way where our government can less the money when in terms of the needs of the prisoner, so they can have or avail pardons or parole so that it can be an economic usefulness for our society, and to prevent unnecessary and excessive deprivation of personal liberty by way of parole or through executive clemency. So, even our prisoners or guilty persons have their personal liberty, and they can redeem themselves in the society so that they will have another chance to prove themselves in our society. So next, towards this towards this end, the board undertakes the following. So not all the prisoners have the qualifications that can avail parole or pardon. So here I will discuss the following that can undertake um by the board. So first is A. It will look into the physical, mental, and moral records of the prisoners who eligibly for parole or any form of executive clemency, and determines the proper time of release of such prisoners on parole. So, when it comes to the qualification, the board should look into the physical, if the prisoner is physically fit and mentally fit or have a mental stability, and also the moral records, if the prisoner has a good moral conduct inside the prisoner, so they can be eligible in parole or any form of executive clemency. And then B, assist in the full rehabilitation of individuals on parole or those under conditional pardon with parole conditions by way of parole supervision. So prisoners are supervised inside the prison, or the cell, and even though they are given the availability of pardon and parole, they are also supervised outside the prison. And next is C, recommends to the President of the Philippines the grant of any form of executive clemency to prisoners other than those entitled to parole. So the President has the privilege to um, recommend any prisoners to be granted a parole or any form of executive clemency. So these are the following that the board undertakes for the prisoners to avail parole and pardon.
Good day everyone. First of all, my name is Christian Marina. I am a member of Group 1. Today I will tackle the Section 3, National Prisoner Confined in the Local Jail. First, who are the national prisoners under the laws? A national prisoner's purposes of these laws is one is who is sentenced to a maximum term of imprisonment of more than 3 years or fined for more than 5,000 pesos regardless of the length of the sentence imposed by the court. To one sentenced for violation of the custom law or other laws within the jurisdiction, the court may not consider the release of pardon parole of a national prisoner who is serving sentence in a municipal, city, district, or provincial jail unless the confinement jail is in the concrete or political circumstances beyond prisoner's control. How do prisoners classify inmates? Europe prison institutions are classified into 5 security levels. First is minimum level. Second is medium. Next are high and administrative based on the level of security and staff supervision the institution able to provide. And there are 5 jail in the Philippines, including provincial, district, and city municipal jail managed and supervised by the provincial government and the Bureau of Jail Management and Technology. That's all. Section 4. Scope of Authority. The Board may consider the case of a prisoner for executive clemency or parole only after his case has become final and executory. It will not take action of the petition of a prisoner who has a pending criminal case in a court or when his case is on appeal. In case the prisoner has one or more co-accused who had been convicted, the director or warden concerned shall forward their prison records and carpetals at the same time. So this means that the commutation of sentence, conditional pardon and absolute pardon may be granted by the President upon recommendation of the Board or the reduction of period of prison sentence only if the case is concluding. You cannot proceed with this executive clemency if the prisoner has ongoing court appeal which it is criminal case. For example, a convicted person who is qualified to this probation but his case has not yet become final will not proceed with executive clemency but only after his case becomes final.
Good day everyone. Before I proceed to my discussion, I introduce myself. My name is Luni C. Amora Jr. I will going to discuss about the probation rules and regulation, section 16. Deferment of the parole when a safety prisoner, victim, relatives of victim, witness compromise. So the definition of this section is if the parole investigation report conducted on the prisoner there is a clear and convincing evidence that his release on the parole will endanger own life and those of his relative and the life, safety, and well-being of the victim, his relatives, his witnesses, and the community. The release of the prisoner shall be deferred until the danger cases. Those who have pending cases but appeal the parole, they are possible that his life is danger, especially his family. The custody will do action to be safe the convicted prisoner, and the PNP must do a further investigation report until the case is cleared, and that's the time the convicted prisoner have freedom to the community.
Section 6. Contents of Petition. Contents of petition includes name of the prisoner, age, previous criminal record if any, whether Filipino citizen or foreign national, if naturalized Filipino, former nationality and date of naturalization must be included, previous occupation, place of residency, present crime for which he was convicted, the trial or appellate court where his crime was processed, the penalty for his imprisonment, the fine of his imprisonment, the, the indemnity and commencing date thereof. Indemnity means it is a contractual obligation of one party to compensate the loss incurrence to the other party due to the acts of indemnitor of any other party. It means that the offender, it is a contract between the offender and the offended party, which the offender has to compensate the offended party due to his act of crimi- due to his act of criminal behavior. Okay, the jail or prison which he was committed and or where he is presently confined, the date he was received for confinement.
Good day, I am Erica and today I will be discussing the Section 13 Review of Cases for Parole under the Probation Rules and Regulations. Unless otherwise disqualified under Section 15 of these rules. So, later on, one of my groupmates will explain the Section 15. A case for parole of a prisoner shall be reviewed upon a showing that he is confined in prison or jail to serve an indeterminate sentence. So what is indeterminate sentence? A prison sentence that consists of a range of years, such as 5 to 10 years. The principle behind indeterminate sentence is the hope that prison will rehabilitate some prisoners. Those who show the most progress will be paroled closer to the minimum term, the maximum period of which exists of 1 year, pursuant to a final judgment of conviction, and that he has served the minimum period of said sentence. So the prisoner shall exceed 1 year for him or her to eligible for parole. Section 14, Grant of Parole. A prisoner may be granted parole whenever the board finds that there is a reasonable probability that if released, he will be law-abiding and that his release will not be incompatible with the interests and welfare of the society. So, once the Board of Parole examine the prisoner that they are not now anymore the cause of any civil or criminal action of the society, then they are now qualified and granted of the parole probation. So that's all. Thank you.
Hello everyone, my name is Elona Jane M. Wong and I am assigned in Section 15, Disqualification for Parole. The following disqualifications are the basis for a prisoner that can be granted of parole. So, the first one is those convicted of an offense punished with death penalty, reclusion perpetua, or life imprisonment. Katong mga prisoners na nasentensyahan og life imprisonment, disqualification for parole to sila. Then, second is those convicted of treason, conspiracy, or proposal to commit treason or espionage. Then, the third one is those convicted of misprision of treason, rebellion, sedition, or coup d'etat. Then, next is those convicted of piracy of mutiny on the high seas or Philippine waters. Next is those who escape from confinement or evaded sentence. Katong mga prisoners na nitakas, kato disqualification na to sila, disqualified na to sila. Then next is those who are granted conditional pardon and violated any of the terms thereof. So we all know kung sa ang conditional pardon, no? Those conditional pardon ay mga conditions na dapat sundon sa isa ka prisoners. Then ang katong mga condition is wala niya nabuhat or na broke niya tong mga condition, wala niya gibuhat. So disqualified na siya for parole. Then next is those whose maximum term of imprisonment does not exceed 1 year or those with definite sentence. Next is those are habitual delinquents, those who within a period of 10 years from the date of release from prison or last conviction of the crimes of serious or less serious physical injuries like robbery, theft, and falsification are found guilty of any of the said crimes a third time or of 10. So, in this case, the prisoners is nagbalik-balik siya sa kulungan na same lang ang iyang crime na nakumit sa gawas. So, disqualified siya for parole. The next is those suffering from any mental disorder as certified by government psychiatrists or psychologists. Next is those whose conviction is on appeal. And lastly, those who have pending criminal cases. So, the said followings are the basis for disqualification of parole.
Good day everyone, my name is Jessa Lanshan and to this video I'm going to discuss the proceeding of the board. Section 17. Interview of prisoner. Any board member or government official authorized by the board may interview prisoners confined in prison or jail to determine whether or not may be released on parole or recommended for executive clemency. So it means that the board member or the government official given and authorized by the board to given authorized to interview the prisoner, which is they will determine whether the prisoner not may be released on parole or executive clemency. The board or the authorized representative shall interview an inmate who was sentenced to reclusion perpetua or life imprisonment or whose sentence had been commuted from death to reclusion perpetua. So, the board or the authorized representative, they will interview the inmate na nasentensyahan ng reclusion perpetua or life imprisonment or those inmate na nasentensyahan ng had been sentenced commuted for death to reclusion perpetua. Before the interview, the board may require a prisoner convicted of heinous crime as defined under the Republic Act 7659 and other special law to undergo psychological or psychiatric examination if the prisoner has a history of mental instability or any cases. So before the board interview the prisoner, they should require the prisoner na those prisoner na convicted of heinous crime. When we say heinous crime, it is example of that is murder, arson, or kidnapping, which is under the Republic Act 765. Also, before the interview, the board should require also those prisoner that under the special law, which is undergo the psychological psychiatric examination to identify if the prisoner has an history of mental instability or other cases. If the board find needs for such examination, in the light of the nature of the offense committed or manner of its commission.
Section 18. Publication of those eligible for executive clemency or parole. The board shall cause the publication in a newspaper of general circulation the names of prisoners convicted of heinous crimes or those sentenced by final judgment to reclusion perpetua or life imprisonment, who may be considered for release on parole or for recommendation for absolute or conditional pardon. Section 19. Objections to petitions. When an objection is filed, the board may consider the same by requesting the person objecting to attach therefore evidence in support thereof. In no case, however, shall objection disqualify from executive clemency or parole the prisoner against whom the objection is filed.
Section 20. Documents to be considered. The carpeta and prison record of the prisoner and other relevant documents such as the mittimus or commitment order. Prosecutor's information and trial appellate court's decisions of the case of the prisoner shall be considered by the board and decided whether or not to recommend executive clemency or to grant a parole. So, in case that the prisoner has one or more co-accused who had been convicted, the board shall consider at the same time the prisoner records and carpetas of said co-accused. Therefore, on this section, it refers that in order for a prisoner to be recommended for executive clemency or to be granted a parole, necessary documents shall be considered, which such like the carpeta. Carpeta is refers to the institutional record of the inmate, who consists of his mittimus or commitment order issued by the court. So after conviction, the prosecutor's information and the decisions of the trial court and the appellate court, any certificate or non-appeal certificate of detentions and other pertinent documents is considered.
So good day everyone, I'm Rana May Payusalan. I'm going to discuss all about the proceedings of the board, section 21 of probation rules and regulation. So in this section, it talks about the factors to be considered in petition for conditional pardon, commutation of sentence or parole. So, here are the following factors that may be considered by the board in the grant of conditional pardon, commutation of sentence, or parole. So, A. The age of the petitioner, the gravity of the offense, and the manner in which it was committed, and the institutional behavior or conduct and previous criminal record, if any. So, if the age of the petitioner, if it is too old already, so it may be considered by the board in granting conditional pardon or parole. So next, evidence that petitioner will be legitimately employed upon release. Letter C, a showing that the petitioner has a place where he will reside. A home or a residence for a petitioner. Next, letter D, availability of aftercare services for the petitioner who is old, seriously ill, or suffering from a physical disability. So, a petitioner who is old, ill, or suffering from a physical disability may be considered or may be granted by the board in granting conditional pardon or parole. So, next, letter E, attitude towards the offense and the degree of remorse. So if the petitioner showing regrets towards the offense that he or she has made, so maybe the board grant the conditional pardon or parole. And lastly, the risk to other persons, including the victim, his witnesses, his family and friends, or the community in general, the possibility of retaliation by the victim, his family, and friends.
So, good morning, sir. Good morning, classmates. So, today I will discuss the Executive clemency. So, Section 26, Executive clemency. So, reprieve, absolute pardon, conditional pardon with or without parole, conditions and commutations of sentence as may be granted by the President of the Philippines. So, ang executive clemency raw ay ang natatanging kapangyarihan ng Pangulo para patawarin ang isang kriminal mula sa nagawa niyang krimen o kasalanan o paikliin ang kanyang sentensya. So, next, absolute pardon. So, total extension of the criminal liability of the individual to whom it is granted without any condition. It restores to the individual his civil and political rights and remits the penalty imposed for the particular offense of which he was convicted. Dito na ibabalik ang lahat civil at political rights ng sinumang binibigyan nito. Nang walang hinihinging kapalit, may mga pagkakataon din na nagtatakda rin ng kondisyon ang Pangulo at ang tawag rin dito ay conditional pardon sa mga kagaya ng yung mga dayuhan. So, exemption of an individual within certain limits or conditions from the punishment which the law inflicts for the offense he had committed, resulting in the partial extension of his criminal liability. So, sa conditional pardon, halimbawa, dayuhan, binigyan ng conditional pardon, maaaring niyang palayain at i-depart at kailangan niyang mangako na hindi na siya babalik sa Pinas. Kung hindi, ay maaari siyang ikulong muli. So, yan yung conditional pardon. So, next, the last one is reprieve. So, deferment of the implementation of the sentence for an interval of time. It does not annul the sentence but merely postpones or suspends its execution. So, meaning, ang reprieve ay ang pagpaliban sa pagpataw ng parusa. Maaari ring hilingin ito sa Board of Pardons and Parole, isang ahensya sa ilalim ng Department of Justice or DOJ. Pero sa huli, ang Pangulo pa rin ang magdesisyon. So, kadalasan ng pagbibigay ng executive clemency ay yung katandaan, issue sa kalusugan o pagpapakita ng magandang asal